Hello there, escrow folks out there. Welcome to Escrow News You Can Use. I've been absent from you for a couple months, so this is going to cover March and April. So I'm sorry for my absenteeism. We have a lot of catching up to do. A lot of things are going on in escrow land. Guess what's been happening? We're seeing some more of those commission assignments again. I thought they'd gone away. Be cautious about them. They're coming back in. And this one particular company keeps talking about the agent's commission and has the agent sign the commission instruction, those commission advance instructions. That you cannot go by the agent's signature on that. You must have the broker acknowledge that. The agent doesn't own the commission. The commission isn't his possession. It belongs to the broker. So you have to be very cautious about handling those, making sure that the broker acknowledges the commission assignment. And along with that, assignments of funds out of escrow. We've been having some questions about bills that come into escrow. We've had some termite companies submit their termite reports thinking they're going to get paid out of escrow. We had an attorney submit a bill for legal services that he had done with a seller thinking he has a lien on escrow. Those don't make liens on escrow. Commission assignments are not a lien on your escrow. In termite inspection, any sorts of bills that come in are not a lien on your escrow. In the case of this one attorney, though, it was interesting. I happen to know him. He's an attorney out of Tucson, and I did some expert witness testimony for him, so I knew he was a good guy. So Joe and I called him up to talk to him about this, and actually, as it turns out, his employment agreement with this client specifically talked about a lien on the escrow of this particular property. So he is a real estate attorney. It didn't surprise me that he had some sort of language like this. And so he sent us a copy of his fee agreement that shows that he does have a lien on this escrow on behalf of the seller. So we were able to process that payment. Be cautious, because just because people send you bills in escrow doesn't give them any rights or lien on your escrow. There has to be an actual assignment from the principal or an agreement by the principal to pay those bills. And if they decide not to pay those bills, you can't, they're not enforceable. So be careful about those. I've read some interesting lawsuits. There's a lawsuit out of Montana against an escrow holder for negligence. This was an interesting case. There was a commercial building in Bozeman, Montana, and on top of that building, somebody had constructed a residence. I'm going to call it a penthouse for a better word. There was a residence on top of this commercial building. The escrow was open. The bank gave a truth in lending statement and a good faith estimate to this borrower for a 30-year loan, 360 payments, a certain amount of interest. Everything was disclosed in the good faith estimate and the truth in lending. When the escrow was closed, the loan documents that came over changed it to an 18-month bridge loan on a commercial building. Now, I don't know much about Montana law, but apparently in the deed of trust, there was a reference to the fact it was a residential property. After the borrower signed, the escrow officer deleted that wording and put in commercial property and recorded that deed of trust altered after the borrower signed it. That really set the borrower off. But what more set the borrower off is she moves into this penthouse, she makes her payments. A couple years go by, or a year and a half goes by, the 18 months, the bank sends her a notice that it's all due and payable. She came unglued. She showed them the truth in lending. She showed them the good faith estimate. They came up with this obscure, what looked like a memo in their file that changed the loan terms from residential to commercial. They swear they sent it to her. It wasn't addressed to her. It didn't have a letterhead, didn't have a salutation, didn't have a signature, didn't have a loan number, didn't have any reference to anything. We think it might have been an internal memo that never got to the loan mortgage department to create these correct documents. The bank actually gave her one-year extension to try to get residential financing, and then another 1-year extension. And at the end of these other 2 years of extension, she could not get residential financing on this commercial building, even though it was a residence on top of the commercial building. So she sold the property and then sued the title company and the bank. Now, interestingly enough, the court's decision about the title company was that the altering of the document from residential to commercial really didn't have any effect on whether or not the zoning changed, because it didn't. The zoning was always commercial, or whether or not it affected the use of the property, which it didn't. So the escrow officer, even though she should never alter a document after the person signed it, it didn't really have any material effect or impact the fact that she still couldn't get residential financing. So the court dismissed the title company, but remanded the case back down for more adjudication in the court. So the lender is still on the hook for their actions of a kind of a bait and switch kind of thing on terms, because they gave her a GFE, they gave her a truth in lending, and then altered the terms, switched them at closing without her acknowledgement or a new GFE. Interesting. There's another interesting case out of Florida on forced insurance, and the more I'm reading about Dodd-Frank, which I'll talk to you about in a minute, this was an interesting case in Florida. The borrower stopped making payments on the mortgage, and the lender started foreclosure. During the course of the foreclosure, the insurance premium became due. And instead of renewing the insurance premium with the, let's say, Allstate, the bank puts on their own forced insurance, but they do lickety-splickety. And you know why they do that? Because typically it's an insurance company they own, and the insurance is way, way high, and it's very expensive, and they just put this on. Well, in the course of this foreclosure, the borrower is still living in the property. A sinkhole occurred on the property, and the property was damaged along with somebody on the property. I don't know if it was the owner, wasn't clear in the court documents, who got harmed. They put a claim in on the insurance policy. The insurance company denied the claim because they said, you're not our insured. Our insured is the bank under the forced insurance, and you don't have any rights for any coverage under this policy. Guess what the court decided in that case? That the owner is a third-party beneficiary of the forced policy because they still have a financial interest in the property. Interesting, isn't it? Which is true, because until the foreclosure actually occurs, that borrower could redeem. Just because they didn't pay the premium and just because they're not named as the insured does not mean they can't claim benefits from the policy. Interesting case. And if you go to the Dodd-Frank stuff under the new mortgage servicing stuff, the CFPB stuff, new mortgage servicing stuff, interesting. They've picked up on this too, that if the lender has to put forced insurance on, here's what they have to do. They have to give the borrower a 45-day notice, then they have to give them a 15-day notice or a 30-day notice, then they have to give them a 15-day notice, and it says that the lender can only put on reasonable insurance based on what a reasonable fee is, that it has to be equivalent to or lower than the premium. Under the forced insurance, there's another little thing that Dodd-Frank put in there, that it has to actually be a meaningful charge for services actually performed. So the lender can't just go out and get this elaborate policy and harm the borrower even more, because if the borrower tries to redeem, they have to pay this forced insurance. So Dodd-Frank ceases that. Interesting. If you go on to look at some of the foreclosure that's going on in the country, I've been studying this and getting some data on it. What's interesting about this is foreclosure time periods in other states. You know, Arizona, we've been able to come out of this bad market very quickly because we have aggressive foreclosure statutes. We've worked through most of our inventory and we are done. Think about this. In the state of New York, the backlog for foreclosures is 57 months. You know, that's 4 3/4 years. It's almost 5 years it takes for a property to go through the foreclosure process in New York. That's not even the worst. Florida, 853 days. That's 71 months. That's 6 years. 71 months. If you think how long it takes to foreclose in Florida, and here's what this time period includes. The lender starts foreclosure, they decide not to do it, they restart it, they decide not to do it. So 5 years goes by and the homeowner has decided that he's foreclosed, so he's moved out. You know what they now call this? There's a now statistic called zombie properties. Zombie properties. These are properties that have been abandoned because the owners got the notice of foreclosure and they moved out. These statistics are startling. In the United States, it's estimated there are 302,000 homes that are zombie properties. 302,000 homes. In Florida, Florida has over 90 zombie homes. 90,000 zombie homes. But think about this. Illinois ranks second with 32,000 zombie homes. California with 28 zombie homes. And in Kentucky, even though they don't have the numbers of zombie homes, in Kentucky, 54% of the total foreclosure inventory are vacant properties. And following that, Washington, Indiana, Nevada, Oregon, 50% or more of the properties that are in foreclosure in those states are abandoned zombie properties. The articles recommend homeowners that just because you get the notice of foreclosure, you might want to just stay in the house until it's done. Our own employees found that out, that sometimes it took 2 years for the lenders to foreclose on the properties. So the word of caution is that the banks are taking so long to foreclose, and it's one or the other. It's either because the foreclosure process is lengthy, it's judicial, it's tenuous, it's very difficult to work through the court system, such as in New York, or the lenders are changing their mind, like in Florida and Nevada. They're changing their mind and deciding not to foreclose. So word of caution out there, if any of your friends are being foreclosed on, they might want to sit tight until the lender actually pulls a trigger on them. That's it for now, folks. Escrow news you can use. See you next month.